What's going on today, guys? So, today we're going to be going over some law enforcement training stuff. I want to talk about case law specifically because, in my opinion, case law is under taught in the police world and it's overly important. So, this is probably, meant for newer cops or people looking at being police officers in the academy, stuff like that, that want to understand this better. So, for example, I'm sure you're probably going to ask, like, what is case law? Why do I care? Right? So, case law for law enforcement refers to the body of legal principles and precedents established by courts that guide law enforcement officers in their decision making and actions. It is essential for law enforcement to understand and apply these principles accurately to ensure fair law enforcement law enforcement of laws. Case law provides a framework for officers to navigate complex legal decisions and to avoid legal pitfalls. It's a critical component of law enforcement training and is often the basis for legal research and case analysis, which, okay, I get it. So, if I had to dumb it down, case law is when you play pool and you put up little gutters or the bumpers, and that's so the ball stays within it. Case law is the bumpers. It is the rules that help you as a police officer stay in the lane of doing everything legally. Because the second you fall over those bumpers, you're fucked, right? You're violating someone's constitutional rights. Now, case law is constantly being made, and it always has and always will be. There are certain kinds of case law. There is legal, like there's binding precedent, and then there's persuasive precedent. So, for example, anything that has come out of the Supreme Court, that is the highest court in the land, that is binding case law. That is applied across all 50 states, period. Now, there are state Supreme Courts where they can make decisions and it only affects the state. So, depending on where you live watching this right now, you need to do a little bit of extra due diligence and kind of research if your state case law is more restrictive than the constitutional, like, state Supreme Court or Supreme Court rulings, because that can happen. Most states, they typically just kind of follow the Supreme Court case laws, but there are some states where in which things are more restrictive. So, let's go into detail of what I want to talk about today. Probably the most important piece of case law you are going to use as a police officer. It is, if you are a patrolman on the street, as long as you're actually doing your job and you're not being a lazy POS, you're going to use this piece of case law every day. And it's Terry v. Ohio, and that's 392 U.S. 1968. So, what is Terry v. Ohio? So, I could just give you, I'm sure you're probably going to leave in the comments, just give me the answer, dude. I don't care. Just tell me what I need to do. But you need to understand the pretext and the story behind it in order to better utilize it in the field. So, for example, I'll break it down as quick as I can. Terry v. Ohio happened in 1968, and it is, Cleveland Police Detective Martin McFadden stated he was patrolling in plain clothes downtown Cleveland at approximately 2:30 in the afternoon on October 31st, 1963. His attention was attracted by two men, Chilton and Terry, standing on the corner of Huron Road and Euclid Avenue. He had never seen the two men before, and he was unable to say precisely what first drew his eye to them. However, he testified that he had been a policeman for 39 years and a detective for 35. And that he had been assigned to patrol this vicinity of downtown Cleveland for shoplifters and pickpockets for 30 years. He explained that he had developed a routine habit of observations over the years, that he would stand and watch people or walk and watch people at many intervals of the day, he added. Now, in this case, when I looked over, they didn't look right to me at the time. His interest aroused, Officer McFadden took up a post of observation at the entrance to a store 300 to 400 feet away from the two men. I get more purpose to watch them when I see their movements, he testified. He saw one of the men leave, the other one walk southwest on Huron Road, past some stores. The man paused for a moment and looked in a store window, then walked on a short distance, turned around, and walked back towards the corner, pausing once again to look at the same store window. He rejoined his companion at the corner, and the two conferred briefly. Then the second man went through the same series of motions, strolling down Huron Road, looking in the same window, walking on a short distance, turning back, peering through the store window again, and returning to confer with the first man in the corner. The two men repeated this ritual alternately between 5 to 6 times apiece. In all, roughly a dozen trips at one point. While the two were standing together on the corner, a third man approached them and engaged them in brief conversation. This man then left the two others and walked west on Euclid Avenue. Chilton and Terry resumed their measured pacing, peering, and conferring. After this had gone on for 10 to 12 minutes, the two men walked off together, heading west on Euclid Avenue, following the path taken earlier by the third man. By this time, Officer McFadden became thoroughly suspicious. He testified after observing their elaborately casual and often repeat reconnaissance of the store window on Huron Road, he suspected the two men of a casing job, a stick-up, and that he considered it his duty as a police officer to investigate further. He added that he feared they may have a gun. Thus, Officer McFadden followed Chilton and Terry and saw them stop in front of Zucker's store to talk to the same man who had conferred with them earlier on the street corner. Deciding that the situation was ripe for direct action, Officer McFadden approached the three men, identified himself as a police officer, and asked for their names. At this point, his knowledge was confined to what he had observed. He was not acquainted with any of the three men by name or sight, and he had received no information concerning them from any other source. When the man mumbled something in response to his inquiries, Officer McFadden grabbed the petitioner, Terry, spun him around so that they were facing the other two. With Terry between McFadden and the others, he patted down the outside of his clothing. In the left breast pocket of Terry's overcoat, McFadden felt a pistol. He reached inside the overcoat pocket, but was unable to remove the gun. At this point, keeping Terry between himself and the others, the officer ordered all three men to enter Zucker's store. As they went in, he removed Terry's overcoat completely, removed a .38 caliber revolver from the pocket, and ordered all three men to face the wall with their hands raised. Officer McFadden proceeded to pat down the outer clothing of Chilton and the third man, Katz. He discovered another revolver in the outer pocket of Chilton's overcoat, but no weapon was found on Katz. The officer testified that he only patted the men down to see whether they had weapons, and that he did not put his hands beneath the outer garments of either Terry or Chilton until he'd felt their guns. So far as to appear from the record, he never placed his hands in Katz's outer garments. Officer McFadden seized Chilton's gun and asked the proprietor of the store to call a police wagon, and took all three men to the station where Chilton and Terry were formally charged with carrying a concealed weapon. So, now that we kind of understand the story of Terry v. Ohio, the officer was just doing his routine patrol, and he saw men acting suspicious. So, I can't testify for everywhere, but for where I work, in order to articulate reasonable suspicion, you need to have some sort of reasonable belief that there is a crime that is about to occur, has occurred, or is currently occurring. And, Officer McFadden was either watching it about to occur or in the process of occurring. So, did he have a reasonable reason to stop and detain these men? Absolutely he did. So, in the process of this, he believed that, they might possibly be armed, so he conducted a pat-down and he located two weapons. Like, it seems very, very textbook, right? So, where is it? I believe it was Terry argued. On the motion to suppress the guns, the prosecution took the position that they had been seized following a search incident to a lawful arrest. The trial court rejected this theory, stating it would be stretching the facts beyond reasonable comprehension to find that Officer McFadden had probable cause to arrest the men before he patted them down for weapons. However, the court denied the defendant's motion on the grounds that Officer McFadden, on the basis of experience, had reasonable cause to believe that the defendants were conducting themselves suspiciously, and some interrogation should be made of their actions. Purely for his own protection, the court held that the officer had the right to pat down the outer clothing of these men who he had reasonable cause to believe might be armed. The court distinguished between an investigatory stop and an arrest, and between a frisk of the outer clothing for the weapons and a full-blown search for evidence of a crime. The frisk, it was held, was essential to the proper performance of the officer's investigatory duties, for without it, the answer to the police officer may be a bullet and a loaded pistol discovered during the frisk is admissible. So, if I had to summarize, in an 8-1 decision, the court held that the search undertaken by the officer was reasonable under the Fourth Amendment, and that the weapons seized could be introduced into evidence against Terry. Attempting to focus narrowly on the facts of this particular case, the court found that the officer acted on more than a hunch, and that a reasonably prudent man would have been warranted in believing that Terry was armed, and thus presenting a threat to the officer's safety while he was investigating his suspicious behavior. The court found that the searches undertaken were limited in scope and designed to protect the officer's safety incident to the investigation. So, in modern day policing, what does this mean? Terry v. Ohio basically set the standard so that as long as you, as a police officer, have a lawfully detained individual, whether that's a traffic stop, a minor infraction, reasonable suspicion, and or like you have probable cause, right? When you first initiate contact with this person and you can articulate that you can reasonably believe that they are possibly armed with a weapon, because armed means dangerous in this context, in this legal context. If you're armed, you're dangerous. Some states look at that differently, but for the most part, every state, do your research. The state I work in, if you're armed, you're dangerous, period. So, if I can reasonably articulate that you are armed, I'm allowed to pat down your outer clothing, right? So now you're going to think, okay, where is a pat down reasonable? So like patting down the arms, that's a little bit unreasonable. But think about where you could conceivably hide a weapon. So very obvious one, the entire belt line, as long as it's concealed, right? People tuck guns in their belt lines, knives, batons, you name it, right? Pockets. Yep. I mean, quite literally, I'm carrying one too, right? So, pocket knives are a thing. Screwdrivers. Could screwdrivers be used as a weapon? Absolutely. So, pockets, sure. Belt line, yes. Ankle holsters for guns are things. So, it's not about the actual limitation of where you can search. It doesn't even define it. It doesn't say, oh, you can only pat down the outer belt line and pockets. No. It is up to the officer at the moment to reasonably articulate where weapons could be concealed. If a dude's wearing a backpack and he can shove something between the backpack and his back and, quickly retrieve it as a weapon, if you can reasonably articulate that, you can check there. And like example, if they are wearing backpacks, now you can't search a backpack, even if you believe he's might be holding a weapon in there, because the backpack is more constitutionally protected because it's a personal item, it's an effect, but you can remove it from the person. So you can always just pop the backpack off, put it on the ground, and you remove that from the situation, and then you do a pat down to the person. So typically with me, I check belt line, pockets, ankles, and like right here on your upper chest, because I've found people who do like the lanyard around the neck with the knife in a sheath, and I've missed it before and it gets awkward. So it's up to you in the moment, because even then you can't really develop a standard, because everyone you talk to is different, and everywhere you talk to people is different. Time of the years are different. If you talk to someone in the winter, you're going to do a Terry frisk different than if you talk to someone on the summer on a beach, right? So, and it's all about your articulation. So if I'm working at the beach and I walk up to a dude in board shorts and nothing else, I'm probably not going to be able to reasonably articulate a Terry stop of this person, because you can see everywhere he could have possibly concealed a weapon, right? If you run into the naked tweaker running in the street in his underwear, you can't really, you wouldn't want to, but you can't pat down this person either, because it's not reasonable to articulate that they are possibly concealing a weapon somewhere, because you can see pretty much everywhere. But that's on you to develop this experience and know where people hide things and how people hide things and where people most likely could keep a weapon that can be used, so that you can check there. So again, it's a pat down to the outer clothing. It is like you are actually patting it down. Once you start squeezing, it gets really weird, because sometimes when you start squeezing and manipulating things, it can be seen as a search because you're trying to manipulate the object inside of the pocket, and that's considered a search. Because a search is a government intrusion into a constitutionally protected area. Your person and your effects, your pockets, all of that is a protected area, and since you, acting as a police officer, are the government, that is you intruding into it. So even though, yeah, you're not in the pocket, but you just start squeezing it, and you're basically trying to like feel it, it's considered a search, right? You're getting way too far into that gray area, so I wouldn't risk it. If you feel it immediately, and you know without like fucking hesitation that, oh, that's a gun, oh, that's a knife, oh, that's drugs, oh, that's a meth pipe, you can retrieve that thing. So, for example, me like 2 years ago, my partner and I, we were rolling down the street and we see this car coming out of an illegal gambling hall. And, you know, they're both super, they get upright, super straight, eyes wide open. Holy shit, it's the cops. This is not the right time. We pull the vehicle over for a violation. It was like registration or something like that. Driver's on parole or probation, one of the two. So he doesn't have Fourth Amendment rights, right? Passenger, super chill dude. But, you know, he's got like a big puffy jacket on, pants, jeans, all this extra stuff because it was winter. It was kind of cold. And me, typically, I tell people what I'm going to do before I do it. It's just, I find it easier. And I tell him, like, hey, man, I'm going to get you out of the car. I'm just going to pat you down real quick, make sure you're not armed, and then we're going to be chill. So as I stand him out of the car, I'm like, hey, man, you got any weapons on you? Nah, man, I'm good. I'm straight. All right, cool. So I put his hands behind his back real quick. And as I literally go down the right pants pocket, I could feel a gun. It's a little tiny pocket handgun. I'm like, hey, bro, you got a gun in your pocket? And he's like, yeah, I do. I was like, oh, okay, that was fucking easy. And, you know, click, click, pull the gun out, and he's got a little .25 handgun in his pocket. So that goes into another case law, which is Minnesota versus Dickerson, which is a case law which, here, let me pull it up real quick just so I can quote it accurately. Minnesota versus Dickerson. So, Minnesota versus Dickerson, I believe, was in 1993. 1993. It is a case of Minnesota versus Dickerson, is a landmark Supreme Court decision that addressed the legality of police seizures of contraband detected through touch during a pat-down search. The Supreme Court ruled that police may seize non-threatening contraband detected through a sense of touch during a protective pat-down search, as long as that search remains within the bounds of Terry v. Ohio. So, what does that mean to you? That means if you're doing a pat-down of a person that you can lawfully, reasonably articulate, right? And while you're just patting down over the pocket and you feel a meth pipe, you know, you feel that hard glass object, it's a stem with the bulb, you can just... Dude, it's a fucking meth pipe. You're allowed to go inside, retrieve the object, and if you're right, you, congratulations, have now just given yourself probable cause to search the rest of the person and his effects that he has with him at the time. And the vehicle, if he's in a vehicle. So, and why are you searching? Because you're searching for furtherance of the evidence. Because where could you reasonably conceal narcotics that would go in said pipe? Literally anywhere. Right? So... Terry v. Ohio is considered a landmark case decision because so many other case laws just kind of like intertwine with it. So like Minnesota versus Dickerson is one. I'm kind of doing this on the fly. I didn't prepare that much, so I didn't think that hard about what else intertwines with Terry v. Ohio. But the next episode I'll find all the case laws that intertwine with Terry v. Ohio really well, and then we'll go into those ones. So... to sum it up, for the TLDR, if you wanted to shoot to the end to get to the right answer because you didn't want to listen to the rest. Terry v. Ohio. You as a police officer, if you see someone and you can lawfully detain them, and you do so, and you can reasonably articulate that they are possibly armed with a weapon and or some sort of dangerous object that can be used against you, you can conduct a pat-down of their person. Whether they have one or not. You don't even need to have any inkling that this person is even armed. But if they look like they can conceal a weapon, you can conduct a pat-down. Because in reality, whether you have the hair on the back of your neck stand up or you have reasonable suspicion because of whatever, that helps, but it's not necessary. Because people are dangerous. No matter where you go, no matter who you talk to, no matter what you do, people are always going to surprise you. The most innocent person you see might be the most violent one you talk to and the one who's carrying a gun on them and that will use it against you. So you, as a police officer, want to go home at night and you need to have the understanding that you can do these things because they stop you from fucking dying. So, if you have any questions about Terry v. Ohio or you want me to go into examples, I can do some research, find some body-worn cameras that do a really good job of articulating these things and showing you. Leave a comment down below and let me know what you think, and I can work on that for you guys. 'Cause I can dig through body-worn camera and we can find better examples. Until then, let me know what you guys think. I'm open for questions all day long. I've always been a resource. I've been a police officer for almost a decade. I've been a field training officer for almost 4 or 5 years now. So I'm happy to help. Happy if people need help. I'm here. So leave comments, subscribe. I'm gonna keep doing case law, and then we're gonna start breaking down body-worn camera footage and going into proactive policing tactics and suspicious human behaviors, ways to start structuring investigations and how to do stuff like this. So, because I've noticed, especially in today's world, police officers are not well trained. The ability to train after George Floyd took a fucking nosedive, and I've seen nothing but parking lot cops who just want to collect a paycheck and not do the fun things about this job that make this job fucking amazing. And it kills me inside because I love doing this job, because I love being able to be proactive, to chase down criminals, and to do all the fun things. So if that's what you want to do, stick around for more, because I want to keep doing a lot more, and I want to help make the world safer by making proactive cops who want to hunt down fucking criminals. So thanks for sticking around. Like, comment, subscribe. Appreciate you guys' time.